We welcome you to panel number 4. We're going to be looking this morning at the changing nature of planning practice in the public sector in the Caribbean. And what we hope to do is to have some observations from our panelists from the various islands, and also look at what are the implications for this changing nature of planning practice as they have observed in their particular territory. We have 4 panelists this morning. We have Ms. Christine Toppin-Alha, who is going to be joining us remotely, Mr. Leonard Francis, Mrs. Sharon Roberts Joseph, who is from St. Kitts, right? Anguilla. Mr. Leslie Hodge, also from Anguilla. All right, and they just recently joined the panel this morning. So I'm happy that they are here with us. And Christine is going to be representing Barbados. So without further ado, what we're going to do, we're going to give them an opportunity to share their observations, indicate what are some of the implications they have seen for the changing nature of planning practice, and we'll give you an opportunity also to question them when they are each finished. All right, so we're going to start off with Christine. She's ready to go. She was ready a whole hour ago, but she is ready at this time. So let me just give you a brief introduction to Christine. Christine Toppin-Alha is an attorney at law, specializing in environmental planning and land law with qualifications and experience in legislative drafting. Among other things, she has 45 years experience in the field of planning and environmental management in the public and private sectors, and over 25 years experience as a practicing attorney and international consultant on environmental planning and land law, policy and institutional arrangements. She has served as a consultant on planning, environmental management, institutional strengthening and legislative drafting to various international organizations, and has worked in every Commonwealth Caribbean country, as well as several non-English speaking countries. Among other things, she has been a lecturer, and both at the Faculty of Law, University of the West Indies, CUF, Barbados, as well as a lecturer at the postgraduate programs in planning and development at the Faculty of Engineering, UWI St. Augustine. And finally, she's also, and this is an abridged version, she's also an experienced legislative drafter for several Caribbean countries. So without further ado, I will now hand you over to Christine, who is going to give her observations on the changing nature of planning practice, with specific reference in this case to Barbados, and therefore hand you over to Christine.
Thank you, Andrew. I believe you are one of my former students too. It's very good to see you in this august position that you have achieved. I'm going to speak really more about the recent legislation we have introduced in Barbados. Of course, you know, planning practice in the public sector is underpinned and guided by the legal and institutional framework for the regulation of the development of land. And Barbados planning law has recently been transformed by the repeal and replacement of the Town and Country Planning Act, which was over 50 years old, enacted in the 1960s, by the Planning and Development Act of 2019. The new act makes radical changes to the administrative system for physical planning and development control, as well as modernizing the philosophical approach to planning. To begin with, I think I should mention the open process by which new legislation has been arrived at and adopted. This began with a public consultation process, which was kicked off by the Prime Minister on the 16th of July, 2018. I mentioned that because it was only a few weeks after the change of government. And of course, she was at that time our new Prime Minister. The initial discussions, which were carried live by the GIS website, were followed both nationally and internationally. And after we concluded the first two public consultations in person, of course, at that time, as well as on the GIS website, there was a green paper prepared, and that was published by the GIS also for public comment. Following the receipt of public comments, both at the consultations and on the green paper, we prepared a bill which was laid in the House in December 2018, which is within 6 months of the original discussions, and it was enacted in January 2019. Later on, it was decided that rather than just simply going ahead with the planning department with its historical responsibilities, the department should be transformed into a one-stop shop for both planning and building approval. And so a further round of stakeholder consultations was held in 2019, and the necessary amendments was passed in March 2020. Therefore, as a result of this very, very inclusive process, there has been general buy-in by the stakeholders, and I include in that phrase both the relevant land-based professionals and developers. I want to specifically note that the Barbados Town Planning Society led all the public consultation exercises and was intimately involved in the development of the new legislation. So against that background, let me tell you what is in this act that, as I say, has had this sort of very inclusive process, development process. In clause 3 of the act, and I won't refer to the clauses other than that one specifically, that one is the one that deals with the purposes of the act. Thornton on legislative drafting, which is illegal, the lead-in text says that a purposes clause should not offer more than the act delivers. And I think that we have delivered on all the things that are in the purposes clause. There are 5 things. I won't read out the full language, but there are 5 main things. The first one is the facilitation of land development. Then the attainment of appropriate standards, and appropriate standards is language that you see in all the treaties we sign, but which we very seldom have in any of our legislation. Thirdly, efficiency and accountability on the part of the regulatory authorities. Fourthly, public participation in decision-making. And fifthly, effective access to redress and remedies for persons aggrieved by decision-making. The new administrative system that we have inculcated into the Act is firmly based on the principles of transparency, collegial decision-making, and public participation, all of which are designed to raise the veil on decision-making that characterize the old system and eliminate opportunities for bias and corruption in development control. The element of collegial decision-making is shared by the OECS countries. Most of you from there would recognize it, but the measures for ensuring transparency and public participation that we have included in this legislation are new to the region. Speaking about the planning provisions in the legislation, to give Barbados credit where it is due, this is the only country in the region which has substantially complied with its statutory obligations vis-a-vis land use planning under the old legislation. As those of you in the know would recognize, Barbados has rolled over the development plan, I think it is 3 times now, whereas most countries have struggled even to get out one statutory plan. However, the process by which those statutory plans were prepared was very outdated and actually was not reflective of what was being done in modern planning practice. Hence, we have in the new legislation updated the system for development planning, modernized it, made it more participatory, and we have also enhanced the legal status of the development plan. Express provision has also been made for the adoption of supplementary planning policies. This is intended to eliminate reliance on what are known as desk drawer policies, which is the bête noire of planning practice in the Caribbean, the Commonwealth Caribbean, I should say. You know, there's a wonderful case from Trinidad called Lopino Limestone versus the Attorney General of Trinidad and Tobago. And in that, the Chief Justice, I think it was in the Court of Appeal, or the future Chief Justice, said that the minister has no right to keep his policy locked up in his breast and spring it on an unsuspecting applicant. Unfortunately, that happens far too often in the Caribbean. So by making a statutory basis for planning policy to be promulgated, as well as statutory plans, we hope we have eliminated that practice in Barbados. As regards development control, we have made some radical changes to the system that existed in the past. With the exception of applications referred to the minister, all major decisions will be made by a multidisciplinary public-private sector board. Only applications of national strategic importance will be referred to the minister, and all applications will be processed by the professional staff of the Planning and Development Department, who will also be delegated responsibility for determining minor applications. Now, the board will decide on what those applications are that can be handled at the level of the professional staff rather than be referred to the board, but there is a list of applications in a schedule which cannot be delegated by the board and must come before the board. Very strict deadlines have been set for the processing of applications. This system is premised on the principle of facilitation of land development that I mentioned earlier as one of the purposes of the Act. You know, a prime minister, and let me emphasize, it's not the prime minister of Barbados, a prime minister in a Caribbean country once told me that the default setting on planning departments is no. So we are trying to get to yes, put it that way, to use the language of negotiations. The Act expressly states that the decisions must be guided by a presumption in favor of granting planning permission. And this was the Prime Minister's brainchild. In cases, and the Prime Minister of Barbados I'm speaking of now, in cases where applications can be approved if modified, an entirely new form of decision, that is to say a provisional refusal, will issue. And that refusal will only become a full and concrete refusal if the plans are not modified and amended to a state where they can be approved. Of course, I say it was her brainchild, but I had to come up with a legal device that would have permitted that to happen. So this device of provisional refusal is one we have introduced into the region into planning law, as far as I know, for the first time. Now, the department will eventually function as a one-stop shop for building and planning control, as I mentioned, but most of the building plans reaching the department will have to be certified by registered professionals who will be assuming general responsibility for ensuring conformity to the building codes and standards. This element of the legislation builds on an aspect of the new legislation, what we call the paddle, that was adopted in Trinidad and Tobago a few years ago, I think 2014, but it has not been yet fully proclaimed. This is very important because it means that, you know, our original legislation, both for planning and building control, was written in an era where we really did not have competent people in private practice, a whole slew of competent engineers and planners and architects and so on. But in this modern era, we can transfer a lot of responsibility for adherence to standards and codes once they're published and they're legal to the profession. And this is what we hope to do and take that burden off of the public service. I should also mention that provisions for the protection of the natural and built environment have been greatly strengthened. And this aspect could be of immense significance in Barbados because environmental law in Barbados is in need of comprehensive review and improvement. Environmental management is the subject of various pieces of unrelated legislation administered by several different agencies. So we have not yet achieved in Barbados the union of institutional responsibility for physical planning and environmental management that was achieved by Jamaica some 2 decades ago, and has just been effected in Suriname, which is itself about to embark on the development of a new spatial planning law. A new and transparent system for the hearing of appeals against the merits of administrative decisions by an appeals tribunal has been introduced in this new act. The system has been depoliticized, regularized, and opened up to public scrutiny. This was a very, very dark area of the law in Barbados before this. Appeals were made to the minister, hearings were held, nobody knew what the other side was saying, documents weren't exchanged, the report of the person who conducted the hearing was not a public report, the decision that was made by the minister was not public, and so on. I mean, yes, the fact that planning had been granted or refused by the minister, but none of the rationale was disclosed. And the right of recourse to the courts of law in order to challenge the legality of decisions is unaffected. So we feel we have really stepped up the recourse part of the legislation as well. But in ending, I need to point out that the potential benefits of the new legislation have not been fully realized to date, because the required institutional strengthening of the Planning and Development Department has not been given the same urgency as was given to the enactment of the legislation. Setting aside the requirements for the startup of the one-stop shop for the time being, because that part of the act has not been proclaimed, there are other capacities that must be built up as soon as possible. For example, establishment of the Environmental Service Unit in the department, which is critical to the new EIA process provided for in the Act and in the EIA regulations. The efficiency of the system for decision-making provided for by the Act depends on as much on having adequate and appropriate staff in the department as on a radical change in the institutional culture of the department. Thank you very much.
Thank you very much, Christine. So you know you're going to be standing by for questions. I just want to, before I go further, I am Dr. Ansel Kirk. I'm your moderator for this morning. My bad, I forgot to say that up front. Yes, there are 4 things that I thought stood out in terms of what Christine said in terms of the Barbados experience with the new Planning Act. The aim is getting legislation that is modernized and fit for purpose, because we know our legislations that we have been working with has been as old as based on 1937 type of legislation. So it's about modernizing the legislation so that it's fit for purpose. Facilitation is the name of the game. And the aim is to arrive at yes. Might be novel for some people in the regulatory system, but the aim is arriving at yes. And the concept of the provisional refusal, that's a unique one. And the urgent need for institutional strengthening. Those are 4 things that I thought stood out. And so at this time, I'm going to open the floor for questions, both from persons in-house as well as those who may be online. So feel free to shoot your questions at Christine, not at me.
Just a comment. Let me just say, Christine, and deep work on the act, well done. I do believe that there will be a change in the town planning system in Barbados. I don't think that act is the primary issue, but Christine raised a point that is very important. 2 points are very important. One is the institutional culture. Institutional culture relates to institutional thinking. I maintain as a person who worked in the planning office, let me say this, I work in the planning office and I work outside the planning office, both publicly and privately. And the most difficult thing with planning in Barbados, in my opinion, has never really been the act. It has been the thinking and the institutional culture. The part about arriving at yes is a critical part of the process. Because I would honestly say, going out into the World Wide Web, that I work with planners who thought that no was the first thought. And I said that as a person who worked inside and a person who worked outside, who worked in National Housing Corporation. So I do take the point that the act needs to be changed, but I think what you made the point about institutional culture is even more critical than the act in itself, some things I see in the act, because we can work out the act and repeal and add things as we go along. But the culture is the most important thing. And the other part is the institutional strengthening. Apart from training, I think just as we were bound to the English legislation, promotion and merit in our system is still bound to MRTPI and all other kinds of external things, which I think has hamstrung the system because we have not brought in planners with different backgrounds. Okay. We have not seized on the planners from the university investing in the coastal zone management. We've not seized on the natural resource management people. We've not seized on the people out of UTech doing different things. We all are bogged down to going to England to study, to train, to come back. And I think that is one of the major jobs. People come back, it's very strange things that are not suited to the Caribbean. So I want to compliment you for your work. We look forward to see it working. But there needs to be a lot of other changes with the culture and the training. The training is more, the training, MRTPI might not be, is a very good nominalism to have, but my experience in Barbados is that people with different facets of planning training are going to be more important to the planning system than even a town planner formally trained. Someone with background in environmental impact assessment training in going forward, and even some engineers with solar energy training understands it might be more important going forward when we're doing the energy and these kind of things than a formal town planner. So I take your point and compliment you, but I hope that we can have some discussion going on your ideas on the institutional strengthening. And just one point, which is institutional strengthening, so that people know a planner in Barbados in the town planning department is one of the lowest paid public officers you can find. And I don't think you're going to attract some of the best and the brightest and the things to go into planning if you want to strength being paid at 6 to 1. Then you can pay a project manager with a first degree at S4, $110,000 a year. So all these things have to go together to make it work. Mm-hmm. Okay, but thanks again, Christine, for the efforts, and I appreciate it greatly. I don't agree with everything, but at least we got some movement and we're moving forward. Thanks, Nancy.
Thank you. And just a little housekeeping as you make your comment, just identify yourself. And so, yeah.
Former work, former town planner department, planner and National Corporation.
Thank you. Thank you. My bad. I should have said it. Don't worry.
I'm not a consultant.
Good morning. Jihan Wallace from the Department of Physical Planning in Nassau, Bahamas. I guess I had two questions. Is the new act available online? Because I don't mind reading it. I'd like to read it because we are in the process of hoping to update our act that was that was enacted in 2010. And so we need an update because there's some issues that we have with it. But I also, is there a section in your act dealing with enforcement? What has been updated to help those who have developed and done things outside of what is allowed in the country?
Thank you very much, Christine. The issue of availability online and the question of enforcement, what provisions are there?
Okay, there's two questions, there are two aspects to that. The availability online, as far as I know, the only copies available online are on our Parliament website. So you will need to look on our Parliament website from January, January 2019, and then March 2020 when the Amendment Act was passed. Barbados government has a philosophy of selling its laws. So we're not like the Bahamas where your laws are very available online. In fact, I have to commend your country for that. not only the laws that are on the law books, but as they come out, the annual laws and so on are all online for the Bahamas, which is some other Caribbean countries have followed your example, but Barbados has not. I imagine in the fullness of time, I haven't looked at their website. They were supposed to be updating the website, that the department will have the legislation on the website. Most departments should have the legislation governing themselves and their clients on their own website as well. But I'm not sure it's gotten there yet. I don't know if somebody from Barbados department can answer that question for you. As regards the enforcement, yes, we have updated the enforcement provisions of this legislation. Also, Barbados legislation did have, unlike Trinidad never had a stop notice. Barbados legislation did have a stop notice, a statutory injunction, which could be put in place immediately to stop people doing illegal, persisting in unauthorized, I should say, developments. However, that has sort of been tacked on by an amendment, and it was not thought through in the act. So, for example, whereas you could have appealed against an enforcement notice to a judge in chambers and all of that, there was no appellate provision relating to a stop notice. So you would have had to go to the High Court by way of judicial review to challenge a stop notice and that sort of thing. Hello?
Yes.
Yeah, okay, so some mic is open, I think. So we have changed up, we have refined the provisions concerning the tools that are at the disposal of the regulatory authorities with regard to unauthorized development. When it comes to the regularization of development, we have maintained the position that you can make a application for retrospective approval, but there has been a financial deterrent to doing that, and that has been in place in Barbados for some time, that an application for retrospective approval will cost you more than an application if you make it up in front. We've also made a number of changes to the schedule, to the development order, which sets out things which require planning permission, but planning permission is granted by the order. So we've clarified a number of things. Of course, planning legislation takes a three-pronged process of looking at development. First, there's a generous definition of what constitutes development, 3 limbs of development as we call it. Then there are 6 things that are accepted out and said that they are not development. That's the English approach, and it's true in Trinidad, true here, and so on. And then there's this device of granting blanket development by a development order. In some countries, it's a schedule to the act and so on. But so that is all intended to minimize the burden on people in planning departments. Now, let me just say vis-a-vis the Bahamas that I've worked there, I wrote a report on your legislation some time ago under a land use project that was headed by Tex Turnquest. There were some reports written under that project, and I'd made some recommendations vis-a-vis your legislation, and I had changing your legislation. This was before 2010 when your new legislation was brought in. I don't know who did your new legislation, and I really haven't made a thorough study of it. But I had made some recommendations concerning that. Maybe you could look back at that. And I would be happy to come and help you with a fix if necessary. That's what I do for my living.
Thank you.
Thank you very much, Christine. I will just take one last question or comment before we move on. Anyone? Identify yourself.
Yeah, Cornelius Isaac, OECS. I didn't understand is it strategic referral to the minister or referral of strategic decisions to the minister, and who does that? Is it the board? What is the process? Just a little elaboration on that, please.
Christine, you got a question? The matter of referral to the minister.
Yes, I'm seeing I'm having a problem with my video. Our legislation in the past had a clause that said that the minister can give a directive concerning the types of applications to come to the minister. That was a very sweeping, and it's a very old directive that said, about subdivision of agricultural land and developments on the coast. So every little application concerning somebody doing something on the coast or dividing agricultural land of over 2 acres had to go to the Prime Minister, who is, by the way, the Minister for Planning. And let me just say that that was originally the case in Trinidad, but it stopped being the case many years ago. But having the Prime Minister in charge of planning is always a good idea, because planning needs to integrate and to be a cross-sectoral operation. So what we did with the legislation is we retained the power of the Prime Minister to give a directive saying what classes of applications should come to the Prime Minister to be decided by the Prime Minister rather than anyone else. But we limited it to being of strategic, environmental, or economic importance, so that petty things. Now that list was being developed by her advisors in the Prime Minister's office. I'm not sure that the new directive has been given, but until such a directive is given, there are no applications that ought to be going directly to the minister. Obviously, one wants to keep to a minimum and to be very important, strategically important to the nation, the things one would trouble the Prime Minister with.
Thank you very much. And my question, in light of what you were saying and what you mentioned earlier on, when you said that the new act depoliticizes planning, in what way has this happened?
I said it depoliticizes the appeals process, right? Because we had the appeals process, which actually your original legislation spoke to, but it wasn't operationalized in Trinidad because it was connected to the delegation to local authorities, which never happened under the Trinidad Act. But our appellate process was one which you would appeal to the minister directly. And therefore, it could be seen that there was a political decision maker that was hearing appeals. Of course, there was this intervening optional hearing, which was always opted for by every appellant to be heard by a person appointed by the Prime Minister, and there was no criteria. There were no criteria as to the qualifications or suitability of that person to conduct a hearing and to give planning advice to the Prime Minister. And as I mentioned too, it was a secret process, a black box process. So we have depoliticized it by providing that there will be a panel, I think it's a panel of 9 if my recollection is correct, of an appellate tribunal, but that whole tribunal will not sit on every appeal. Every appeal that comes forward, 3 persons will be selected at random by the chair of the tribunal, obviously. 3 panels of 3 will be put together so that the responsibility for hearing appeals will rotate between the members of the panel. And the reason for that is, of course, for it to be unpredictable as to who is going to hear your appeal when you make that appeal, and so that the appellate tribunal itself doesn't become a center of power or subject to politicization, pressures, and so on. And then the whole process, the process by which the tribunal will operate, is also one that is specified in the legislation, and its whole decision-making process is to be public, and everything has to be published. So I think we've introduced transparency and taken out the politicians completely from the appellate process.
Thank you very much, Christine. Good for you. There's a similar situation with our act in Trinidad. I would just say that what has happened in this case, Barbados has jumped ahead and fully proclaimed. We have partially proclaimed since 2015. Pretty soon we will join you, I am sure. Thank you very much, Christine Topin Alaha, for a very, very wonderful presentation. We now go on to the second presenter, panelist, Mr. Leonard Francis, and he's a director of the Spatial Planning Division of the National Environment and Planning Agency in Jamaica. So Francis is a trained environment and planning professional with over 20 years of environment and planning experience. Among other things, he has been a guest lecturer at several universities and is an adjunct lecturer at the University of Technology in Jamaica. Possesses a master's degree in planning and one in business from the University of Ryerson, Toronto, and so on. So without further ado, therefore, I present to you Mr. Leonard Francis.
It's on? Sure. Hello? All right, so thank you very much. I would, before I start, I'd like to give some thanks because I think it's very important in that being here, it took an effort for me to be here. And I must thank Assad, the OECS, the CPA, Government of Jamaica, and several other organizations. And flying down also, the airline itself, Cayman Caribbean Airlines coming down. I said, you know what? I cannot. So I must thank the pilot as well, because that was very important to actually reach in here. So we must give thanks. We must give thanks. Now, the efforts to actually improve in the spatial planning framework in Jamaica, and that's how we actually looked on it. We actually put together, we wrote down, and then we look on the various aspects of the spatial planning framework, and then we try to improve it within itself. And just for those of us who might not understand, just quickly, the spatial planning framework, as we see, it consists of people, technology, the system, processes, institutions, the various laws, and the other quirks in the system. Our first presenter actually spoke of some of them. There are several black boxes as well, in which we are trying to eliminate totally. Now, part of a process in that for years we have been working on improving the spatial planning framework. And in respect of the national spatial plans, we had 2 national physical plans before, and we've been trying to get the national spatial plan done. And we know a draft national spatial plan, but it has not been signed off as yet. The idea, though, is that we want this national spatial plan to be such that, I'm not going to say what you want because I Carol, it's not going to happen. The idea, though, is that we want the national spatial plan to be enshrined in the law. So every single government agency that has anything to do with planning, they will have to conform to the national spatial plan. So if we're going to build a road, it must be according to what is in the national spatial plan. That is very important because most of our countries, the planning system is not integrated per se. There are various other agencies doing different aspects of planning, and sometimes we're working at cross purposes. So that is something that has been drafted and something to actually be done as well. The town and country planning law, we have drafted a totally new town and country planning law, and that has been drafted for quite some time. We have spent a lot of time updating it, and we have actually been pushing to get it into law. We have not achieved it as yet, right? It's actually going through the process, but very, very slowly. So hopefully between this year and next year, we will add some giant leaps in which it actually becomes law. But in Jamaica, the town and country actually talks about development orders, right? So, but what we do is that we actually do development plans. Those are done at the local level, right? And then coming out of the plans, what we do is that we do what we call the development orders, as most of you would have been familiar with. Now, what is interesting is that there was a point in time in which the development orders, they were really outdated. Not outdated, they were dated because they were being used, so they would not have been outdated. They were dated. Then we have embarked on a program, and that program was led by several chairs, but I remember a lady by the name of Dr. Carol Archer. I don't know if you know of her or anybody knows her, in that when she was a part of the Town and Country Planning Authority, she took a personal interest in that process, and we started. So most of our development orders are now up to date, right? They are no longer dated, and we have pledged to try and do them every 5 years. So we do have those guidelines that are there. We've also embarked on a process for doing smart master plans, and we have done one for what we call the Greater Negril area. We have done one for Aqua Tree, for Coastal Spring. We're doing also smart streetscape plans. And so what we have done is that we have gone ahead and we have got an architect that is in-house, and we are actually getting architectural technicians and plans to actually work along with those. So we have created another unit to ensure that the process moves ahead. Now, because of how the system is set up, we have the central government and local government. Now, unfortunately, at times, they do not necessarily work well together. So, under the direction of the CEO and of the authority as well, what we have done is that we have created a framework that we have regular monthly meetings, in that we can put on the table what the various positions are that needs to be dealt with, the various issues that needs to be dealt with. And it does help, I must say, it does help that the fact that the present permanent secretary of the Ministry of Local Government is a planner, and that person has ensured that the process is happening. Now, we also embarked on a national densification project, in that part of the process in the development orders was about actually looking on increasing densities, responsibly, very responsible though, and sustainable. And that, because the idea is that we're still a lot of sprawl was happening. And in the national settlement strategy, the idea was to concentrate developments within various nodes in a responsible manner. What has happened though is that everybody was excited about it. But when we start to implement it, Assad, there's a difference. When you start to see these new shiny buildings start to go up, right? And even before they start, some of the developers, in my opinion, are not really responsible. They are not talking to the communities. People don't like to see strange new people around them, bad word, dust, all those things. So you do have a pushback. And then when you start to have higher buildings in areas where you're just used to having 2-story or single-story, there is a pushback. But in Jamaica, though, the construction sector was the sector that was contributing a lot to the growth and development. Even within the COVID time, the construction sector was booming. So there is now a very interesting tug-of-war going on between the various citizen groups, those who are at the developers, academia. Everybody has something to say now. And there have been several court cases coming out of the densification project based on covenants, judicial review. Trust me, a lot of people are getting famous, right? Because some of the lawyers actually take on the work and they're in the newspaper. So every single day, that discussion is going on in Jamaica. Now, our densification program, what we did is that we use what we call a node and corridor approach and the special areas. So the idea was that the majority of densification would take place within the various nodes. And densification is based on several factors, of course, which I don't necessarily need to go into now, and along the major corridors and within areas that need redevelopment. That was a concept that was used basically. Now, what we have also done, because the Town and Country Planning Act as it is right now does not talk about public consultation, except when you are doing a development order. But as a great planning practice, what we have done is that we have gone way beyond what is necessary. So in developing the development plans and orders, we have wide-ranging consultations, and we do take our time. In projects as well, that consultation is encouraged, but it's more encouraged if the development is going to vary from what is in the various development orders. Now, what we have done is that, and when I'm speaking from us, I'm talking about Jamaica, but I'm also speaking specifically Planning Agency. That's where I'm the director. And that is a national agency for planning and environment, right? But what we have done as well is that within NEPA, we have created what we call a GIS platform, interactive platform, using the ArcGIS backbone. But what we have done is blocked it from actually being accessed from outside. In that, we have created this platform which we have loaded on every single dimension within the agency. Because the idea is that whether it's processing, writing plans, or doing anything whatsoever, that data, you could actually query that data. Like just like you run any queries that you do, and then like you run an SPSS query, just for argument's sake, if you are into that. In that we could say, all right, which areas have the most pollution and as box site, so you could actually interrogate the platform like that, and that will help you in taking decisions. Because what we want to do is that we want to go more to smart technologies. Sorry, planners, I'm going to try and put you out of any job. But the idea we're trying to do is to actually go into smart technology, actually assessing, processing applications, writing of plans, doing research or otherwise. So that platform is actually there. We had actually years ago adopted the Amanda system. That is an automated management system for applications. And the plan is to integrate it with the GIS interactive platform. What Amanda does, anybody here else, anybody here, Amanda, any at all? It's a software from Canada, actually. So what it does, basically, applications are loaded on, all applications, from the municipal corporations, NEPA, elsewhere, and that system is used to track all applications. An applicant can, if you have your number, you can log in, and when applications are sent to the various agencies, they respond as well through that system. So it makes the system transparent, although I would like to see it much more transparent. And you can know which officer actually is processing the application, how long it has been with them, and if they have exceeded time frame. Because most applications are over 90 days time frame. That's the maximum it should be dealt with. Some development orders state that if you are exceeding 90 days, you can appeal to the minister directly. That is what is there as well. Now, one of the greatest challenges that we are having is having everybody to abide to the various development orders and plans, right? And because developers are developers, and the fact is that they are always trying to outdo each other aside. It's very interesting in that sometimes for us it's very serious, but for a lot of developers, they are very competitive. And we all know it is about making money. Right, so that is an issue that has to be dealt with. Now, another issue that needs to be dealt with is an infrastructure. That as we are pushing ahead, the idea we have plans where the sewage would have been rolled out, the roads would have been dealt with, all of those will be in place. But those were moving a bit slower than the development itself. So there's a catch-up process that should be going on. Now, part of it as well is that we have the forward planning section, and we call it National Spatial Strategy Branch that actually looks on plans. So what we do is that falls under my watch as well, is that we ask them to look. We don't want it to be trying to play catch up. You should be proactive. So what they have done is that areas that are emerging, issues that they are seeing, trending, papers are written on those. So we have been doing a lot of planning research in terms of noise, renewable energy, lot sizes, because the government has announced that in 5 years' time we should have 60,000 houses. So we know that there's going to be an issue, and we have been doing that as well. We have been looking at entertainment zones, open space, overwater structures. But all of these that we are doing, I'm just advising you, ensure you look at your covenant issues. First, we used to say lift the covenants first, but then we have changed the policy and said we'll approve subject to you lifting the covenants. Whichever approach we chose, there's always a challenge. I think we ought to go back to lifting the covenants first, because the residents have got more active, which is good, because that's what we were encouraging in Jamaica, in that we really want the residents. But how do I say this? There are different residents and there are different reasons with respect to covenants, lifting of covenants. Now, so that is something that we believe has to be dealt with. Now, from a visionary perspective, and I'm wrapping up quickly now, in that we have been having this in respect of, as I said, we are looking on smart communities. We spend a lot of time on that. We believe that there is a need for exchange program of planners within the Caribbean. We believe that's very important, right? We should exchange ideas. We should try and have more Zoom calls, but we also believe that if we can have exchange of planners within the Caribbean, you could be at the same pay. It's easy to access your money, but we think that's important. I think that's part of it. And we're also pushing to have that within Jamaica itself, between the local authorities and central as well. We have not reached very far with it, but it's something that we are pushing as well. We have put in place an air monitoring system in that to gather information on the air quality around the island. We also believe that we should try one for noise and other type of systems, and that will be part also of the interactive platform. So it's a real-time network to address air, noise, and other sort of pollution as well. Now, cemeteries have been a big issue, and probably at the next, we need to have a discussion, probably at the next Caribbean Urban Forum, because in Jamaica, we're actually running out of space to actually lay our beloved ones. And beloved ones are not only people. Animals are also very important for some of us, right? Don't pay attention to the lion in Jamaica biting the guy's finger. Don't worry about that. No, the fact is that we are saying, listen, we cannot afford more space to bury people. So look on innovative approaches. And one innovative approach we have been trying to encourage amongst the person in fire cemeteries, let us have virtual cemeteries. Basically, in a virtual cemetery, you will be disposed of whatever way it should be disposed of. So you make a choice, burn, whatever else. But we're going to keep your memory. So you can go online, touch a button, and you want to look for grandma. You're going to see grandma picture. You're going to see every famous work by grandma, where grandma lived, where grandma died, everything that grandma's ever done. It is placed in that virtual cemetery. And with the software it is, you can even interact with grandma. So who say you cannot speak to the dead? Who say you cannot speak to the dead? All right. No, something else that is happening. Something else that is happening that is important is that we are seeing a rise of pod schools. Everybody know pod schools, right? Or pod workplaces. A pod school basically is that because of COVID, like 3 parents would come together and you would have the class at home. But that in itself is a challenge to some neighbors. But it's going to happen more. It is something as a planning system we have to address. Also, pod workplace. With COVID and the others that are coming, and also with rising prices, we're going to find it's easier for us to meet at Assad's home and work from Assad's home this week, the next week from my home, virtually, by the way. But that might pose a problem because planners are purists. You don't like the idea if there's a single family here, 3 of us are meeting to work. Plus, working, a lot of persons don't like that, but that is itself is something we have to look on. As we move to working from home even more, there is going to be an issue now that what happens to the stores, what happened to the shops, what happened to the offices. As planners, we have to think about repurposing some of these to be homes or otherwise. As we start to move more to autonomous vehicles, parking spaces will need to be converted. And we're saying, let's just blow them up and create home spaces with them. Now, part of the process we are trying to push for, and I've been a recipient of that, is to get the planners and strategic committees. That's very important. So if there's a committee that deals with roads, agriculture, train, railway, whatever else, we try and get some of the planners on there so that the decision making will have that there as well. I'm going to wrap up now. I have a longer list, but I'm going to wrap up because I don't want to take in away whatever. But part of it, the planners lecturing in the process, lecturing in the schools, lecturing in the universities, so you can exchange ideas and you can look on new talent that is coming up to be recruited in the system. Now, part of the thinking, I have a little group that we think, and sometimes I think we're a bit crazy, in that, how are we going to protect the Caribbean cities from rising sea levels? It is something we have to address right now. Are we going to look on floating buildings? Are we going to empty our aquifers that when the water rises, or create new areas that water can be stored when it is rising? Are we going to build gates that when it is rising, we can actually block off these cities? That is something we have to look on. Or are we going to look more on floating homes, floating cities? Part of the thinking we have as well is that should the Caribbean have a satellite, have our own satellites? Or should we be thinking about launching our own satellites and also launching our own spaceships? I don't know, but it's part of the thinking. And the last thing I want to put out there that since Carl said I should not be too philosophical, is urban planning in the metaverse. More and more people are going virtually, right? We're all phobics, you know. We're not going to go virtual, but everything is going virtual. And as planners, although we're not doing so well in the physical universe, when we will now have to move to the metaverse, and hopefully we can plan the metaverse much better, because more people will going on virtually to do every single thing. Vacations, shopping, whatever you do, worship, whatever you do. So that is something we have to start think about seriously. Thank you.
Hold on, I know there are many comments, so we're going to take them very, very quickly, but Leonard, you're getting better with age, boy. You made cemetery, which is a dead issue. You brought it to life, boy.
Sexy.
All right, so questions, so Dr. Mohammed.
Okay, thank you very much for a very stimulating presentation. First of all, let me make a comment and then a question. I'm always excited when I hear about densification. My partner, Raymond Lord, behind here, got me excited when he started about densifying social housing in Barbados a couple of years ago. With one of the most spoiled parts of the world. We'll talk about Anguilla, who will speak a little afterwards. Very spoiled place. So anytime I hear about densification programs, well thought out and planned, I get excited for the region. That's a comment.
That's very
right. Christine introduced the idea of the rolling set of legislative that will require institutional reform in the region. You've introduced a whole new set of issues around, and we had a whole panel just now around digital modeling, reform using remote data and analytic techniques and so on. And you yourself raised the question, as to say, you're not trying to put the planners out of work. But it does raise a question that, and the other existential issues you raise around understanding and dealing with climate change and sea level rise, it does raise a question which this panel is supposed to start to think about, is obviously changing in nature of planning practice, certainly public service. You have to do a whole new set of things that you did before. And we want to take this question to the CPA. What does it mean in terms of the existing capacity and training of planners? Are the people we have being trained adequate? Do we need to send information to the training programs in the region? Do we have to ask questions about how we accredit and register planners and accredit the programs? So these are some of the issues which will come out of the changing nature of planning practice. So I don't expect you have an answer for all of those things, but I think we have to be aware of some of those types of issues.
Yeah, thank you very much. Dr. Mohammed? Anybody? that dead, leader there. You have somebody in the corner there?
Me again. Listen, Manasseh is 21 by 7 miles, so any talk about where do we put dead people, I will listen to, because we have no space. And of course, no one wants it next to their their subdivision. So that's a huge problem we have right now.
Yeah.
It's a huge problem. Listen, we will take any idea right now. But the conversation you were having about the densification, do you have any legal, moral, social responsibility for right of sight of those who live nearby in their single or two-story structure, and then next door you have an approval or you want to approve a 4 or a 5-story structure, and of course their issue is, well, now I can't see the beach or I can't see my hills. How do you balance the need to densify versus those people who are existing who don't want that in their space?
Well, that is a constant battle. And but the fact is that when we're planning is coming from, before we had planning laws, you could do anything you want to do, right? So what planning does is take away some of your rights for all of us good. Now, that in itself is a challenge. But what we have done is that, and let me be honest with you, I don't know what to say, but I don't know, we asked for a streetscape plan. So it seems as if we have done the best we can to address your concerns, and then we go ahead and approve the plan. Read it how you see.
I saw the
But the reality is this, though, that we cannot continue to destroy our forested areas, good agricultural lands, environmentally sensitive areas. What we need to plan, and I don't know if we had prepared the people sufficiently enough for densification, because let me put it this way. Everything you read before the densification started, and what is said, let's densify. But everything you read after the densification started is, no, we don't want it here. But there are choices that have to be made, and they have to be responsible choices.
Thank you. Permit me to just allow one more. Christine she has a question or comment. We take that and then we go on to Anguilla, please.
Thank you, Ansel. Mr. Francis, I wanted to draw your attention to Section 18 of our new act. When you talked about the fact that you want the National Physical Development Plan, spatial plan to be legislated, I am aware that you have this very ancient and unique, I could say, piece of legislation, I think from way back when, that really is not fit for purpose at this point. I'm glad to hear you're making progress with replacing it. But when I mentioned earlier that we talked about the status of the physical development plan, that's in our section 18. And you may want to look at that because we provided there some of the things you want to say about your plan. Firstly, that every public officer shall have due regard to it as far as practicable, be guided by the plan in formulating and preparing any public sector investment project, right? Secondly, that the board that is reviewing applications has to give principal consideration to the plan in deciding. And thirdly, that any person exercising a power to grant any fiscal incentive or other form of public sector assistance for carrying out any private sector investment project must ensure that the proposed project is consistent with the plan and has been granted planning permission. So we have 3 things in there that would help you in formulating your ideas to make sure that there's adherence to the plan. I must compliment you. I've been familiar for some time, or never seen it in operation, with the digital tracking system you have for applications. And it seems to be terrific. I know you've had it for some time and probably been working on it and refining it. And I think that's something that is absolutely essential. The government here believes in digital by default. So I'm hoping that something similar like that is being introduced. I've heard some talk about it. In terms of the comment that Ms. Wallace just made about the effect of intensification, high-rise buildings, and so on, the law concerning that is very old. There are certain rights to light and right to air and so on, but there's no such thing as the right to a view in the law. So that it depends very much in terms of planning policy and whether or not you have a development order or a zoning plan or whatever that allows that intensification to take place, because it cannot be prevented under the common law under any right to a view. I mean, we all love a view of the sea, but we can't say that's a legal right. But at the same time, some of the rights that we do have under the common law need to probably be revisited by legislation. And that's one. And for example, the right to light. We have a lot of solar panels and solar powered things in the Caribbean now. And there's actually no right there's a right to light, but there's no right to direct receipt of the radiant properties of the sun. So that you might need to have, for example, just like you could have an easement to walk over somebody else's land, you may be wanting to have an easement over somebody else's land in order to receive sunlight on your solar panels. And that is something that we have not done in the Caribbean so far. So that there are a number of things we need to look at background laws outside of planning law as to whether or not they support the legislation. Finally, I would refer to your cemetery, and there's a really amusing case from Jamaica about the De La Peña funeral home trying to have a new cemetery somewhere in the countryside. And one of the themes in the case report is whether or not the neighbors were really objecting on environmental grounds concerning their groundwater and so on, or was just that they didn't want to have duppies next door.
All right. Check. Thank you very, very much, Christine. I wouldn't let Leonard respond. But thanks a lot for your intervention, because we're running out of time and we must hear from yes, we must hear from our friends from Anguilla. So Ms. Sharon Roberts Joseph, she's going to introduce herself and then she's going to give us her observation. Thank you.
So this is on, right?
Yeah.
Well, I'm Sharon Roberts Joseph Hodge, and I am the Deputy Director of Physical Planning in Anguilla. I've been working with that department for 27 odd years. I've been deputy about 20 of those years. I was trained both in Canada and in the UK. And I must start by saying it's been an upward battle in Anguilla with planning as a whole. We come from a culture where planning is fairly new to Anguilla. I still say that, even though our department was created in 1990, but it is still new. And having said that, we have land ownership pattern in Anguilla where about 98% of about 92% is privately owned. So that in itself is a planner's nightmare. Having said that, we have tried, one of our aims has been to change the culture in Anguilla of acceptance of planning. And to compound that, we've had legislation from the 50s, from the 60s, our Building Act, our Planning Act, and we have tried time and time again to, we have had drafts that's been prepared by Christine from as far back as 1996. And every couple of years, it has not been adopted. Mainly due to political will, unfortunately, every time we think we're getting close to having our planning act, that planning bill passed, we change governments and then we have to start from scratch again. So we're nowhere as sophisticated as the Jamaica context, even close. And it's created a lot of problems because here we're in a position where, acceptance of planning on the island is problematic. At the same time, and we have legislation that's inefficient. At the same time, we have the populace who is very legal minded and challenging a lot of decisions that's made for applications that come in and are refused. We've had quite a few judicial reviews, and we've even had applications that's gone as far as the Privy Council. Jason can speak more, Leslie can speak more about that. So looking at our perspective, although we have had a lot of disappointments as far as getting a modern piece of legislation to guide planning in Anguilla, I still think we have made some leaps and bounds in the fact that we have been able to bring about more public consultation, more awareness of planning in what planning is all about. And we have a very robust system of interagency consultation. And I think that would speak to what, sorry, I can't remember your name, what you spoke about, in the sense that, in planning departments, it tends to be very like-minded, and we need more diversification. So I think we get that in being in a small community when we call on other agencies from different backgrounds, what have you, to give feedback on our applications. I think we have that rich sort of that rich involvement in the planning process. Yes, so that's where we at. It's been a hard upward battle, and we're still driving. I don't know, Jason, if you can come in with some innovations as to what we have actually managed to achieve.
Sorry. If I may, Leslie Hodge, Director of Lands and Surveys in Anguilla. I'm not a direct planner, but I have had a stint at planning in my earlier days, and I'm also part of the committee, the Land Development Control Committee, which is the planning committee. And I've served on that board since approximately 2014. Yeah, okay. It's a lot. No, okay. Okay, I've served on that board since 2014, and process they have seen, we have had a number of iterations of the planning bill. As Sharon said, from 96, there have been continuous amendments, and there's a draft national land use plan that is sitting there. Has been shelved since 96, but we have had other iterations, 2003, 2006 or 8, thereabout. And then I think in 2013, we also were part of the OECS Quick Wins project, where we identified some of our institutional gaps. And that again started the ball rolling to making amendments to the Act. Mr. Isaac will know a bit about it, Cornelius. And then in 2015-16, we had Christina come across to do our amendments to our legislation, which really we thought we were on board to having that final step in place. And I would say that it was a move in a good direction, especially we got more buy-in now. More persons are seeing the need for the bill. From the aspect of streamlining decisions, because of the old act has to go through a longer process, etc. And also the challenges of going to, which Barbados has, and going to, if it's a refuse, it goes to cabinet for a decision. It is not tabled to the professionals in that area. So we are finding that more of those decisions that may be approved, once they refuse, might be from a political standpoint, not really in the best interest of the entire island. Right. So those are some of the things that our new legislation, which Christine helped in drafting, would address in this case. And so really, where are we after 1960? We haven't gone much far, but we have done those incremental steps in terms of implementing certain parts of the policy of the bill, the draft bill, into action. So
also to what we have done, without a comprehensive bill, we are forced to create a lot of policies that govern. I mean, we have policies for as we work and we see the need for certain key things to be done, we then create policy, and it's approved by the Executive Council. And so the hope is eventually when we get this act passed, we can, a lot of these, this will form the basis for, some key elements that would be critical in our act.
Yep.
Yeah.
In addition to that, as we do, so for some, in the case of Anguilla during Hurricane Irma, a lot of our paper records were close to being destroyed, and we started to embark on a process of scanning almost all the data that comes in. I can speak to these two departments. Planning as well. Now, every application that comes in is scanned into a system. So in the event we do get to computerizing that system, we'll have them scan, and then we can easily go ahead and upload those. And we actually overlay them over the GIS now, so we can make better informed decisions in terms of radius, whether it's in a low-lying area, the sloping, etc. And then we can look at that. So
it makes for better informed decisions. Yeah.
In terms of innovation as well, though, we have had some discussion about marina development, and there's no marinas in Anguilla at present. So there has been talk about that for a number of years, but quite recently, we've had a company that has had a marina feasibility study completed, and they're currently in the discussion of the marina development. And that, in a sense, would actually address some of the outcomes from that project, would actually address some of the deficiencies we have in one of the areas, which is Sanagong. It's a low-lying area. In some cases, it's actually below sea level. There's a tide gauge gate 2 miles of the water there as well. But in that sense, the marina development actually in that area, the number of the homes have been there since the 60s, 50s. A lot of them would have had sewage treatment plants. It's sandwiched between a pond, a wetland, and the sea. So with septics, not the best situation to be in that area. So the marina development envision a central sewage treatment plant for that. And also any new development will be raised. So in terms of sea level rise, it would try to alleviate some of that as well. And also there's only one main exit out of that area. So again, in terms of accessibility to get in and through and through from that place, we also would have a secondary road to get out. So that was one of the areas that we are working on right now. And I think we have also, from a plan perspective, have started to do a special area development plan for that area. Seeing it's very, very unique, I would say. Yeah. So in a nutshell, I would say that is not going to go into the burial aspect. but
Although it's a problem, a real problem.
But we have science.
Science.
But one aspect that we have seen an increase in the request for private burial sites.
Beside, in the midst of residential
Areas.
developments, we
Right.
just dealt with one, and this person happened to be the person who started the first funeral home on the islands. Of course, his family wanted a mausoleum for him, and they wanted it right next to their house, in the midst of a residential area. And we've had more requests for things like that. And at the same time, like the Bahamas, we're running out of cemetery space as well, and then you have these requests. So I don't know, we really might have to take on board that virtual cemetery concept.
But lastly, if I just may.
No, go right ahead. Go ahead.
Lastly, if I just may, to Dr. Assad point though, in terms of densification, we do see the need for that because of the benefits that actually come out of that. Because of our spread development is really a cost on our infrastructure, and that sends up the bills.
Yeah, the electricity bills,
Electricity,
and
water, etc.
water, everything. It's
Yeah.
very expensive to develop in Anguilla.
So, Dr. Assad, I'll take that point ahead.
Yeah.
Okay. Now, I have been given just 5 more minutes into your lunchtime, so I want to use it wisely. I apologize. Yeah, so I apologize for us having to do this and for you all having to be rushed. I take full responsibility. Christine has a comment and she's going to make it briefly. Yes, Christine?
Yes, as you would gather from the remarks just made, I have been in and out of Anguilla for some 25 or so years, working on legislation there. And I think there are really three things that will really affect or has affected that process. One is that notwithstanding the size of the community, there's a very powerful legal lobby because, you know, Anguilla is a center of international financial dealings and they have a very sophisticated law profession, so that there's a lot of resistance from the law profession to changing this legislation. And they have put a spoke in the wheel more than once. Another thing that is really quite typical, I think, particularly in the smaller states in the Caribbean, is a determination of people in various departments to protect their turf, regardless of whether or not that's a good idea. So that, you know, people are very jealous of their jurisdictions. And if you try to put various things together and say, look, this will be more efficient way, for example, joining planning and building and so on. Most of the countries you have a one-stop shop in most of the OECS countries, but places like St. Kitts, Nevis and Anguilla, building is still separate from planning. So you have this sort of turf issue where people don't want to give up any of their so-called powers. It's really responsibilities, but people see it as powers. And the other thing, and I think that Sharon was just alluding to it, there is an undercurrent in Anguilla of people who want to hang on to the old ways of doing things. So they like to talk about their customary practices and so on. So in that context, given that they also have a lot of thrust of international development, you know, 5 or 6 star hotels and so on, and subdivisions that are also targeted to the international market, you have a tension between people wanting one philosophy with regard to development standards for their local population, their belongers, and another for the international development. And I think that that's not a viable route to take in the long run. You know, appropriate standards means appropriate standards for us all, and we shouldn't be discriminating between a community that is populated by persons of Anguillan origin and a community that is to be populated by foreigners who are buying in. So there are a number of factors behind there, but you know, as Sharon said, you know, the misfortune has been that every time we're almost there with the legislation, there's a change of government, and there may be no substantial change in the philosophy, but it just gets, you know, that's the last government's thing, so let us do it all over again. So that's all I have to say, but I wish you all well in Anguilla, beautiful place. And last time I was there was right after the terrible devastation you suffered in the hurricane that you just mentioned. You lost your documents and everything. And I hope you're well on the way to recovery.
Thank you very much, Christine, and thank you very much. Good, very good.
Well, I don't know how.
It will have to be good.
Yeah.
Don't run off, please don't run off.
Sorry, I don't know how quick it can be, but it's for Leonard and Christine, because in looking at the whole legislative process, we do need to give some consideration to ethics in professional practice, and I don't know to what extent that has been covered, Christine, in the new legislation in Barbados. I know we are struggling with it in Jamaica in terms of the built environment practitioners. How do we legislate their the professional practice and adherence to certain you know, ethical consideration in the practice?
Yes, I could say that basically we are hoping our first reliance in Barbados is going to be on the transparency aspect and information sharing so that people cannot act corruptly. We're not creating forum for people to act corruptly because, as I said, many people in the Caribbean, and this is something that was said to me by a PS in another country years ago, mistake responsibility for power, and then they exploit that power. But we have also introduced very severe penalties. And of course, that is the fallback. We don't want to go there in the first instance, but there are very severe penalties for taking or soliciting a bribe, but also for a person offering and paying a bribe, so that the public servant is not only going to be punished, but the person in the private sector who is attempting to corrupt them will also be very liable to severe punishment. So, so we hope we can rely on the transparency devices in order to raise the level of ethics in the profession. Now, also we have legislation dealing with the allied professions in place already, architects and engineers. We mentioned their certification, but we're also working on a registration of planners act. I think you've done that in Trinidad, Ansel, already. We worked on that for many, many years in Trinidad, which of course has a code of ethics attached.
Thank you very much. Thanks, Christine. Thank you, Leonard. Thank you, Sharon. Thank you, Leslie, and thank all of us. And we want to assure Leonard his cemetery issue is not a dead issue. We'll keep it alive. We'll not bury it. Thank you very much. Enjoy your lunch.